trusted colleague, Adrian de Hautecloque, from the cabinet of the President of the General Court. And he will actually kick us off today to take us through the first set of cases on competition-related issues in the energy sector. Then I'll take over and I will deal with state aid and also some recent administrative cases, and then we'll turn the screen back to Adrian. And if you have any questions, please post them in the chat and we'll see if we can take them on board as well. So off we go. Thank you, Adrian.
Thank you very much, Lee. Good afternoon, everyone. We've been doing this case law update for quite some time. It's always a pleasure. We have, I think, quite many cases to discuss. And me, for now, I'll stick to the two main competition cases that we had end of October. I think my slides, you can see them now. Here we are. So first is EDP. It's a preliminary ruling that will be for appetizer before we go to the big one, which is Bulgarian Energy Holding, a massive judgment of 230 pages, and so it will take a bit more time. So, but just to sort of warm up, let's have a look at this little one. It's a preliminary ruling. So as you know, in these preliminary rulings, the court does not rule on the case, but just give indications as to the interpretation of EU law to the national court. And so there it's interesting because we are looking at an association agreement between an electricity supplier, EDP, and a consumer product retailer, in particular food retailer called Modelo Continente. We are in Portugal. And these two undertakings deciding to join forces to cross-promote, and this implied some sort of market sharing between them, in the sense that the food retailer committed not to enter electricity supply and vice versa for a few years, so as long as the scheme was going on. So in essence, the scheme was a discount scheme for consumers. So the consumers had both to take the discount card from Modelo Continente and to enjoy the scheme, to sign a retail contract with EDP, and they got a 10% discount on the electricity bill and some diverse discounts from Modelo. So the Portuguese Competition Authority went after them because it thought that it was a restriction of competition by object, and so that there was an infringement of the national provisions mirroring Article 101 TFEU. And one of the main problems is that the scheme was implemented at the moment where we went out, where we were going out of the regulated tariff era in Portugal. And so that was really a way, in particular for EDP, to get a lot of consumers. And so there, the issue was, in particular, the notion of potential competition, because really what was really restricted by that agreement, if we take into account that Modelo Continente was not an electricity supplier. So because 101, of course, applies when there's a joint conduct that restricts competition. And so there, the test, which was devised in particular, but not only, in generics, UK and Lundbeck, the idea was to look at, if there wouldn't be that agreement, would there be any concrete possibilities for market entry? So not just a possibility, because there's always a possibility in the end, or an intent, even if you have to take intent into account, but where there are some concrete possibilities. And there the court, and I think very logically, said that if you have a non-compete, there's an indication that there's potential competition between the two parties to the agreement. On top of that, Modelo Continente was part of the Sone Group, which was supplying electricity in the past and owned a cogeneration plant. So there was some knowledge in that group, even though the court is not getting into the issue of is there between the Sona, all the branches of the Sona group, is this a single economic unit under competition law? But so was looking at that and said that's an indication that it's not impossible, at least, and that there's more than a possibility for Modelo Continente to enter into the electricity market. And so, yes, there was potential competition to restrict. So that was the first thing. Then the two undertaking made different arguments to try to escape the equivalent, the national equivalent of 1011. In particular, they said that it was a vertical cross-agency. We should consider their association agreements as vertical cross-agency contracts. Why is that? Is because they wanted to rely on the guidelines on vertical restaurants, which set up conditions under which you can escape 111 through getting exemption with 1013 TFEU. In particular, they said that there were like two agents for each other. But the problem is that agents in agency agreements do not take risk, and they just represent and sign contracts on behalf of the other companies, but they take no risk. Whereas there in the scheme, the whole risk were really shared between the two entities, and so the cost of implementing the scheme was borne, not half-half, I think, but they were borne by both entities. I think an argument that had a bit more potential was the argument as to whether the non-compete in the scheme would be only ancillary to the main agreement. And there, the idea is that if you can sever the restaurants from the main agreement, which is obviously good for consumers, then you could get a pass on that one. Of course, there the question is it severable from the main agreement, or are there any less restrictive alternative? Because of course the restaurants must be as limited as possible to be acceptable, and this is of course for the national court to look at it. And there was also a question about is it a restriction by object, by opposition as to a restriction by effect? And there the court said that, yeah, it's likely that a market exclusion agreement, and we have had plenty of them in energy, in a liberalization context, we are at the end of regulated tariff, is probably, when it's signed by a dominant player, a restriction by object. So that was the first case I wanted to talk about. So the second case is much bigger and way more difficult also to synthesize. So it's a case of last October 2023. The alleged infringement of Article 102 this time, so abuses of dominance, occurred between 2010 and 2015. There was originally a complaint by Overgas, which was a Bulgarian gas supplier at the time, which was linked to Gazprom, I think, up until 2021. And so there's a bit of a strange context, because if you remember well, Gazprom at that time was probably abusing its dominant position in Eastern Europe. And we have all that big case where we had also several court cases about the abuses of dominance of Gazprom. So you have all this context that's a bit that has to be taken into account at least. So Bulgarian Energy Holding and related companies, so in particular Bulgar Gas and Bulgar Transgaz, is a vertically integrated company which is dominant, and I can say like that because it was confirmed by the General Court, which is dominant on the gas infrastructure market, which means upstream on the pipeline between Romania and Bulgaria, and then on the transport network, and then on the only one, at the time at least, gas storage facility called Shiren. And so there, the theory of harm was that there was a single and continuous infringement, as we say, in the sense that the BHN related companies altogether coordinated to implement a big host of different tactics at the three level to ensure there was no possibility for third party to get access. One of the peculiarity, so you're back, Lee. I'm not sure. I don't know if I'm sharing my screen anymore. Whatever. And one of the peculiarity was that Bulgar Gas did not own the pipeline facility. The pipeline facility, so the only one pipeline that imported gas through Ukraine from Russia to Bulgaria, was owned and operated by Transgaz, which was the Romanian TSO. However, following an international agreement that was signed a long time ago and renegotiated in 2005, Bulgargas, against an annual fee, which was kind of considered as an investment in the pipeline, could get 100% of the capacity on the pipeline. So the Commission framed the refusal to grant access to grant access as a refusal to deal at the three levels, and decided for a fine of 77 million euros. And what was interesting is that the General Court quashed the decision of the Commission almost, I think, for the first time, at least on substance, for an Article 102 case. So that's why it's interesting to look at it a bit in more details. The General Court found that indeed Bulgargas was dominant, and that indeed there was a lot of difficulties to access, in particular, the gas transit pipeline. And you can see from the judgment that the whole issue is really the issue of the gas transit pipeline. And I'll come back to that in a minute. And so the General Court did not deny the fact that there were difficulties to access the pipeline. However, there was an issue with attributability, in the sense that the difficulties were not attributable to Bulgargas, but in essence to Transgas, and there were also other arguments. So now we'll get a bit more in detail into the case. As far as the definition of the relevant markets are concerned, there's nothing much to say. Everything was confirmed. Just maybe it's interesting to see that the General Court confirmed that probably in that case, the primary and the secondary capacity markets on the transit pipeline were one and the same relevant market, even though it wouldn't change much as to the appreciation of the dominant position. Still, there are some interesting development there. As for the dominant position on the transit pipeline, so the dominance come from the fact that, as I said, Bulgargas has access to 100% of the capacity and is the only one that is reselling on the secondary market the capacities, and actually some operators got a bit of capacity in the secondary market. Transgas also needed consent from Bulgargas to resell the capacity when Bulgargas didn't use the capacity in the first place. Of course, that was not a very liquid market because the secondary capacities were always very short term and interruptible, and so it was not easy to enter the market. So there, the issue is not that it was easy or not to enter the market. No, it was not. Then the question was whether it was really attributable to Bulgargas. So here, I think is one of probably the main question is how to characterize the abuse on the pipeline, because the Commission framed the case as a Bronner type of case of refusal to deal. So maybe we can come back to that just one second. So Bronner is a fairly old case. It's more than 25 years now. I think it's 1998. He was in the newspaper business, and someone set up a retail network for home delivery of newspapers. And someone, Mr. Bronner, Oscar Bronner, I think, came and asked for access against, of course, a fair fee to this retail network, and it was refused. And that's how we got the three cumulative conditions, which needs to be fulfilled to have a dominant operator to oblige him to give him a duty to contract. So the three cumulative conditions: a refusal to deal makes entry impossible in the real estate market. There's no feasible alternative, and there's no objective justification to the refusal to deal. And so the Bronner conditions are very restrictive. It has always been considered very restrictive. And why is that? Is because we don't want to hamper the incentives to innovate, even of dominant companies. And of course, there's the whole argument about the freedom to contract. And so Bronner conditions are very restrictive. And so that's why when we are essential facility type of cases, seems to me that usually the Commission tries to escape the Bronner box. You can see that, for example, in Lithuanian railways lately. We've seen that in energy, for example, in all the commitment decisions that we had in the 2010s, in particular, for example, ENI, but also others. So we say, okay, it's essential facility type, but you don't need to fulfill the Bronner conditions. There, the Commission, I think, had no choice but to frame it as a Bronner type of abuse. But even though, of course, it's always a bit surprising when you are in energy, it's because, of course, the pipeline is a true essential facility. Because there to import gas to Bulgaria, you need to have access to the pipeline. And of course, it's not really easy to replicate a pipeline tomorrow. Of course, Bulgargas in this case controls the facility. So there, I think there's no doubt about that. And also that the annual fee amounts to an investment in the pipeline. This, I think, is not really discussed in the judgment, but I think that's also what also gets us back in the Bronner box. So once the General Court confirmed that Bronner was applicable in that particular case, which is in the end quite specific, the General Court, however, decided that the Commission did not establish that there was an unlawful refusal to deal at all, and for actually quite a few interesting reasons. Of course, first reason was that a lot was, in essence, and you see that the judgment is really going into details, and it's extremely thorough analysis, I have to say. That's why also it's so long. But a lot of it is attributable to Transgas behavior. The second thing is that some of the other operators obtained access despite the functioning of the secondary market on the pipeline. A third reason was, I think, interesting, is that actually in concrete, Bulgargas did not oppose, it seems, the access requests. The Commission has said that, but the evidence, it seems, did not show the same way, and was actually rather constructive in granting access to those who wanted that. And there came in again the notion of potential competition, because it's true that some operators went with some sorts of exploratory questions to request access, but it doesn't mean that they had a real plan to enter the Bulgarian gas market. And so in the end, there was no potential competition to restrict in these cases. And also the judgment made clear that to have a Bronner type of refusal to deal, you need to have an explicit request and an explicit refusal, which you didn't have in this case. And I think it's fair because this is exactly what you can find in Bronner. There's a lot of development concerning the international agreement that was renegotiated in 2005, and where, in a way, but not really saying it very clearly, I think, the General Court took into account some sort of state action defense. We said that, yeah, when you abusive behavior, actually you had no choice because you were just, I mean, maybe how could I say that? But let's say um, following up on what the state decided, then you're not responsible for what you did. And then it's true that in that agreement, it was a lot about the security of supply of Bulgaria, and that it was fair for the company in the state to make sure that they would have a 100% access to the pipeline. So a whole sort of argument, in a way, diluting the responsibility of Bulgargas. The Commission did not establish either fully that there were refusal to deals on the transmission market and for the most part at Shiren. And that's why, even if it was true that there were some anti-competitive conduct, especially on the storage facility and on the transmission market, it was not enough to back the operative part of the decision, which was really based on a single and continuous infringement. I think one thing that is really, really interesting is that the court found that it's true that BH adopted an anti-competitive modus operandi, but it was incapable of restricting competition downstream as River lacked access to the pipeline for reasons which were not attributable to Bulgargas. And so even though Bulgargas were doing some bad things downstream, in the end, it didn't have, in a way, the potential to restrict competition because it was impossible to access the pipeline anyway, but for reasons that were not linked to its behavior. So I think that's that's quite interesting to see. There were also procedural irregularities on the case, in particular the recording of documents relating to meetings with Overgas and the functioning of the information room, where, of course, the representatives of the parties had access to some information, but what they could get out was too limited to allow the companies to exercise the right of defense. So you have a few pleas there that are interesting. So I think a very interesting case overall, pretty hard and heavy to swallow before Christmas. But we don't know if there will be an appeal yet. I don't think there's one introduced, but there's still time, so we will see. Back to you, Lee.
Thank you very much, and thank you for digesting what is indeed a very heavy judgment, very long. I think it's over 1,000 paragraphs, if I remember rightly, but I captured the essence of it very well. So I will now move on to state aid, and we have a number of interesting cases, and Max is happily sharing my screen. Some of them are a bit familiar, and I'll try and get through them very quickly. The first one is a case called Estwind, which we've actually, I think, also looked at in one of the previous installments of this webinar. And it concerns one of these kind of recurring issues in state aid law, what is to be considered start of works, because for state aid to be deemed compatible, one of the most important tests is that it has an incentive effect. So if you've already started constructing something like a wind farm, and then having gone on to do that, you claim state aid, then it's questionable whether or not you satisfy this test of incentive effect. And if you're giving money to someone who's already doing what the member state in question wants to do. So there has been quite a bit of past case law, and of course we do have guidance from the Commission, but as in many of these cases of guidance, the guidance isn't very clear, and there are provisions in what is now the old set of environmental aid guidelines from 2014, where this concept is explained to some extent, but then there is a footnote which kind of complicates how to deal with this concept. And it is, as I say, an ongoing issue, but it is important because it's a concept that appears not just in the guidelines in the past, but also in the current climate and energy environmental guidelines, and also in the bulk exemptions. And what was important here was, in fact, that Estwind was trying to apply for a new scheme when it was already an existing producer. And it was an existing producer that was to benefit from an additional scheme to allow for the construction of a wind farm. And they had done some preparatory work to move into this new area. And this then was an important concept. Were they actually starting new works? And the court looks at this definition and comes up then with, I think, a fairly common sense approach. And if the wind farm construction site had already been subject to preparatory works, and if there was a complete and irreversible commitment to actually go forward with the construction of the project, then in the court's view, EWP should then comply with all the provisions in the guidelines and should be eligible then for aid going forward as an existing producer. So this is a good clarification of something that in practice, although perhaps legally it doesn't sound like a very important point, in practice it often actually is quite important, because otherwise the beneficiary could find itself challenged and having to pay back the aid, which would be unfortunate. So moving on to the next case. This is again one we've touched on before, and this is really just to remind us that the concept of an interested party who can lodge complaints before the courts to challenge Commission decisions is still very restricted. And here it was a trade union who had complained to the way the Commission was assessing an amendment to the French ARENH scheme. This was a scheme which had also been deemed state aid in the past, and it was updated, and the trade union complained that these amendments would actually prejudice its members for various reasons. The Commission didn't take their issues on board, so they challenged this eventual decision before the General Court, and the General Court followed, I think, the usual strict interpretation of what an interested party is. So this means often for trade unions, for NGOs, it makes it very difficult to rely on state aid law to challenge decisions of your government, which was what was really at issue. Here it was the amendments in France to the scheme that were particularly problematic. So moving on to the next one. And here also, this is one that we've seen before in previous seminars or webinars. And here, this is quite an interesting case. We now have a challenge to the General Court's findings. The General Court had actually rejected the Spanish company Naturgy Energy's complaint that the Commission had opened a formal investigation. So as you'll recall, state aid procedures comprise two parts. the opening decision, where the Commission is supposed to come with a reasonably quick finding. And if the Commission has serious doubts about something, then it should move on to a formal investigation, which obviously can last a lot longer. And third parties do have the possibility of submitting written observations at this stage. But Naturgy found that there was no justification for the Commission to open this formal investigation into a Spanish measure that was aimed at desulfurizing its coal plants. And in particular, the company argued that the Commission hadn't actually justified its decision to open the formal investigation in sufficient depth. And one of the issues that it took issue with was the concept of selectivity, because allegedly these measures were addressed to all operators of coal plants and therefore should not, at least in NE's views, have been found selective. Now, the Commission said, well, wait a minute, this is the arguments in the opening decision, where we then come to a conclusion that we do have serious doubts, are only preliminary, and we can develop our reasoning. We, the Commission, we can substantiate our reasoning at the next stage, at the formal stage. But it's interesting here because the Advocate General sides with the aid beneficiary and says, well, if the Commission does decide to open the formal investigation, this obviously has implications, and quite serious implications, for the aid beneficiary, because if the Spanish government has followed all the usual requirements and notified the aid for clearance to the Commission, then they have to wait until the Commission finalizes its investigations and adopts a formal decision. So this can take quite a long period, and therefore, in the meantime, the beneficiary does not receive the aid. So for those reasons, the Advocate General takes the view that the Commission should indeed have given clearer reasons. So this is it'll be interesting to see what the Court of Justice makes of this case. Moving on then to the next case, I've added this. It wasn't actually on the list we publicized, but it's a very short ruling, and whereas poor Adrian had thousands of paragraphs to read, this one, I think, was confined to 2 pages. But it's quite an important case. It concerns the railway sector. So not really an energy case, but it's one that has quite a bit of relevance for any sector, because it concerns the application of the market investor principle. So the Czech railway operators had sold some of its operations to, in fact, a student body. I'm sorry about the misspelling here. And that was challenged in the national courts because they had not sought to clear the terms of that sale. So they hadn't notified it for clearance. So they had breached all the procedural rules, at least in the view of the complainant. But this case was an old case, in fact. You see, it was from 2008. And in accordance with the procedural regulation that implements the state aid rules, Article 17 of the procedural regulation from 2015, the Commission can no longer recover aid after 10 years. So after that limitation period has expired. But the question before the court, coming from the Czech Supreme Court, was, well, what about national limitations? We have no limitation under Czech law. Do we have to then apply the EU limitation period? And the court says no. It's a question of national law, subject, of course, to the usual conditions of equivalence and effectiveness. So that's actually quite an interesting case. And the reasoning, it follows earlier case law where the Court of Justice has said, well, if the state hadn't notified it shouldn't, as it were, be allowed to use this limitation period under EU law to shield itself from damages under national law. So that an important case. Next one, please. This one is also a saga, which we've touched on before. And what's quite interesting here is one of the issues, in fact, that was argued before the court was that this case should no longer be admissible because, or the Commission's decision should not be considered admissible because it had taken such a long time to actually reach a decision. The issues arising in this case go back to 2011. It's 12 years ago. Of course, the Commission had been intervening, so we're not talking about the statutory limitation period here. It's just that each stage of the procedures took a long, long time. This was a case which concerned the way German transmission tariffs were constructed at the time. And there was an article in the relevant law whereby the Federal Energy Agency, the Bundesnetzagentur, had been mandated to give an exemption from certain network charges to large users. And this it was a rather complicated way that this exemption was put into effect. It was challenged at national level, and actually that decision was quashed. The network agency's decision was quashed, but in the meantime, lots of challenges were lodged before the German courts. One of those courts made a reference to the Commission to ask for some clarity as to whether or not these measures were aid or not. And meanwhile, many of the large users, as well as the German government, challenged the Commission's eventual decision that this network charge exemption for these large users was in fact a state aid. Now it's quite a complicated case, and it really turns, of course, on the question of whether or not we are in the state aid box, where these tariffs actually state resources. But it's quite interesting to note that the Commission tries to kick the case out of court by claiming that the beneficiaries of the aid and those parties then who had raised the action were out of time because they had not challenged the Commission's decision within the 2 months that is normally required to lodge a challenge. And the Commission said they knew about this decision quite a long time before it was published in the official journal, and therefore they should have mounted their challenge within 2 months from the date they actually knew about it, and not from the date in the official journal. This is a trick, an argument that comes up again and again and again, and the Advocate General dismisses this and said it's the date of publication. So it's the date of publication in the official journal, and that's of course important because it gives people a lot more time to prepare. But still, it demonstrates that it's a bit of a dangerous game if you only rely on the publication in the OJ. Okay, so going back to what was the key here, the key issue was whether or not this network charge exemption was to be qualified as state resources. And this is an ongoing issue, and it's partly an issue that has resurfaced because the case law of the court is really not very clear, and the case law seems to evolve from one case, one judgment to the next in a very pragmatic way, where a lot seems to turn on the facts of each case. And what was particularly problematic after a case that we refer to as the EEG case, that was a ruling of the Grand Chamber of the Court of Justice in 2021 on German network tariffs, of which this particular case was indirectly related. But in that case, that EEG case, the court seemed to introduce two tests as to whether or not to determine whether a tariff exemption would be a state aid or not. It wasn't enough just to say there was a levy at issue. That seemed to be the normal way we looked at these things from previous case law. The court in this EEG case has said, oh, there also has to be an additional test that there is state control over the proceeds of this levy. And earlier case law seemed to indicate that those were two alternative tests, not two cumulative tests. And the Advocate General then has to approach this argument also in the light of the case law that has come after the EEG 2021 case, and in particular, Spanish case Dobeles Hess. So the Advocate General he goes into some detail on this earlier case law, so it's worth reading this. Again, a rather long opinion, but still he clarifies the case law, and he emphasizes the difference between this EEG case and the rest of the case law, and says these two cases are alternative, these two tests. So if the levy in question is mandated by the state, that's it. You don't have to then apply the additional state control case. So let's see what the court makes of that. There are a number of cases. There's the case brought by the German government, but there's also a case brought by another set of users, Infineon, all on the same issue. So this will be a very important ruling when we get it, and we'll talk about it hopefully the next time. So moving on to the next case, and I see we're running out of time a little bit, so I'll try and speed up so that we can get back to Adrian to look at the pending cases. This one I can really dispose of quite quickly. This is about the standard of review that the ACER's Board of Appeal should apply. Now, we had a discussion before about the Aquint case, and the issue here is whether or not the Board of Appeal, which is the first station of appeal, if you like, the first tier for an appeal against an ACER decision, whether it should conduct what we call a full review, so it looks at all the facts and the law, or it should have restricted itself to a marginal review, a limited review, where it only looks to see if there has been a manifest error or manifest failure of assessment of the facts, or a failure to apply the law properly. So the key issue here was that when the court was asked to consider whether the board had merely applied this marginal review of a decision of ACER about as to how to award a gas booking platform function at the German-Polish border. The ACER had failed to develop and produce proper evaluation criteria for these tenders. The board had quashed the first ACER decision. ACER took a new decision and, in fact, selected two new operators, and however not OPG, who then challenged the decision. What was, I suppose, a little bit complicating was that the ACER regulation had meanwhile changed. We have the recast regulation, which changed the powers of the Board of Appeal. So the board can no longer annul an ACER decision. It sends it back to ACER to make a new decision So what did that affect whether or not the board was justified in only carrying out a marginal review, while the court here could be quite short, because that issue had in fact already been decided in the Ackland case. So although the board must act quickly, it has to take a decision within 4 months, it still is required to carry out a full review. So the next case is, if we can move on, Max. It's a very important case, and although it's not directly related to state aid control, it is a key plank in developing a more effective control over the way the European bodies decide to finance various projects. And this was a case brought by Client Earth. And Client Earth had, in fact, challenged a decision of the EIB, the European Investment Bank, the EIB refused to conduct what's called an internal review, as required under the Aarhus Convention, which is in turn implemented into EU law by a regulation. At that time, when this case was brought, it was a regulation of 2006. Now that regulation requires then that the act in question has to be an administrative act, and the EIB, supported by the Commission, tried to argue that the General Court had actually committed also an error of law by finding that its decision, the EIB's decision, to approve the financing of a biomass power generation plant in Spain was an administrative act, not an exercise of its own sort of financial review. This was one of the main grounds of the challenge brought by the EIB and the EC. There were several other heads of appeal, but unfortunately we can't go into all in detail. But what I think is very important is that the CJEU takes a very teleological approach, looks at the purpose of the convention as implemented by the regulation, and it affirms that this type of financing decision is subject to the convention and the implementing regulation, and therefore the EIB was under duty to conduct this internal review. That means the EIB then takes a decision, which also then, of course, can be challenged in court. And this is why for state aid decisions, this step in the Aarhus Convention implemented through the regulation can provide to a way into challenging some of these decisions, whereas, as we've seen from the trade union case mentioned earlier, it's very difficult to claim to be an interested party in state aid law. But here, of course, it's the NGO that's requested the internal review, and if they don't get it, then it is obviously a party affected by the decision in question. So finally, moving on, we have one more case, which is quite interesting. And there, I think, just to be very brief, this case really shows the court's deference to security of supply and urgent measures that have to be taken in the interests of security of supply. Now, this case concerned a tender for the coordination of tender to set up a platform to coordinate gas purchases in the wake of the energy crisis. This platform has become known as Aggregate EU. Now, the Commission did not follow a normal open procurement procedure, but rather it applied a much shortened procedure, so-called negotiated procedure without prior publication of a contract. That would have been justified only, according to European procurement law, by the urgency of a situation. Now, there is an alternative, and that's called the urgent open procedure. The Commission could have done that. So here, a rival platform argued that they could have qualified, they could have met all the conditions that were required to set up this platform in a very short space of time, but they were not allowed even to submit a bid because they weren't even invited to participate in the tender. So that was then the reason they lodged the action for annulment of the Commission's decision to restrict these tender procedures. So there's quite a lot of interesting arguments made by NMAC that, in fact, it was doubtful that it was really so urgent because it took about 10 months to get the whole thing set up. So was there really a security of supply issue at all here? Now you see that the court doesn't really want to go into all the facts, and so it gives the Commission quite a wide discretion there. I think that's sort of a normal way that the court deals with these types of cases. If the institution says there's a security of supply issue, the court tends to accept it as its word. So that will be an interesting, perhaps an interesting precedent for a lot of the other challenges that have been brought against the emergency measures adopted in 2022. Adrian, the last word is yours. You still have about 5-10 minutes to go through the pending cases.
Yeah, thank you very much, Lee. A lot of very interesting cases you discussed. As to the pending cases, here they are. So it's only, of course, a selection, and there are many. So I will run you through that as quickly as I can. And so you were talking about NMAC, and that comes handy because we'll have other challenges concerning EU and national measures that were adopted in the impending energy crisis. So at the EU level, we have a few challenges before the General Court challenging the regulation and price intervention, and one big case before the Court of Justice concerning the regulation on coordinated demand reduction introduced by Poland. And Poland introduced a series of appeals, all raising, in essence, the issue of the legal basis. And so this one we will have to follow carefully and discuss. Again, I point to your attention the recent electoral preliminary reference that was introduced a few weeks ago on the calculation of windfall profits. And so now we see that we get the cases also through the national courts. At the national level, of course, these are the stated issues, and in essence, it's always either that my competitor benefits from the end and I don't, which is unfair, or I don't and it's normal, but I should not finance it. And so you have two cases, I think, interesting, one in Spain and one in Germany. So that's for the energy crisis. Then we have the cases related to the taxonomy regulation. So in particular, the two delegated acts, the one concerning bioenergy and forestry, and the other one concerning nuclear. So on the one concerning nuclear, we have had already two appeals declared inadmissible, but we have all the other ones pending, and these ones are also very important, I think, with, for example, in the Austria Commission case, lots of interveners, and so they are all with the same formation of judgment. So we'll see how it evolves, but this we will have to follow carefully. On the regulatory side, many cases, of course, so there is really just a selection because we never know how they will, if they will proceed up until the end, in particular because we get them almost exclusively through the preliminary ruling procedure. And so you have plenty on energy taxation, on the EU ETS, consumer protection, etc. I singled out just a few. The first one is the only one we have as a direct appeal, which is the renvoi in Nord Stream 2. So as you remember, Nord Stream 2 appealed the modification of the gas directive when it was modified to kind of extend the unbundling provisions to infrastructure linked to third states. And there, when Nord Stream appealed, the General Court decided that Nord Stream was not directly concerned, and this was quashed by a judgment of the Grand Chamber of the Court. So now it's back at the General Court, which will have to rule, of course, on what's the remaining scope of the case, and then on the substance. And there's a lot of, I think, a lot of interesting arguments. There is one I found in Finland on the power and independence of regulators. One in Bulgaria on who bears responsibility to constitute minimum oil stocks, which is, of course, important now that we'll have minimum reserves for different commodities in different areas. One where we already have the Advocate General opinion concerns a consumer law, and what does that really mean to be able for the consumer to switch supplier easily. What are the conditions that should be there, in particular in the contracts? So on that side of things, we have also a lot of cases. We have now a new stream of cases that echoes what you discussed concerning the client EIB cases, so which concerns the application of the Aarhus regulation. There we have different things. One is a request for a review that was denied of the regulation that was adopted end of 2022 on the acceleration of renewable deployment. And we have also the ones where it was had the request for review of the climate plans by the EC was denied, and so of course these refusals can be challenged before the General Court. So we see more and more of these cases, and so that shows the relevance of the Aarhus regulation. Sorry, I'm going quickly, it's already 3. So the ESA case is just to show you the number compared, for example, to the next slide, which are the competition and stated cases. And see, when I see on the court's docket, the General Court and Court of Justice, you have almost as many cases concerning ESA now than concerning state aid and competition together. So they are also coming. When you see in 23, we had actually 1, 2, 3, 4, 5, 6 cases again, and some introduced and again there by the Bundesnetzagentur and Germany's national regulatory authorities and member states coming after ACER. So that's really a stream of cases that is not drying out. So I was mentioning competition, state aid, and competition. There's it seems to me, no 101 and 102 cases there left, but we have still the second wave of appeals concerning the RWE on asset swap. That should be over soon, because I think we will have the judgment in a week now. So this is the second wave. And so in state aid, so you talk about most of them. Or some of them, because we have the Advocate General's opinion. There, I would draw your attention to the one concerning Hungarian nuclear, which this one I think is most important, and the end of the DI saga also. So I think that's about it. Yeah, thank you.
Thank you very much, Adrian. Thank you. I know that we're past our time. I don't think I saw any questions in the chat. Maybe if anyone has a burning question before we are shut down. Eleanor, are we allowed to stay on for a few minutes? Or
Yes.
Yes. Okay. So if there are any questions, but I think it's I think most people have had to go. Short session. But as you've seen from the list, There's some fascinating cases just decided, but also a lot of really important pending cases. And we'll be back next year with the next installment. Yeah, yeah. So it's always a pleasure to be able to do this and to review the way energy law keeps evolving, keeps us all busy. So thank you very much for joining us. Thank you, Max, for helping us, and also thank you to the FSR and the Schumann Center for getting everything organized today. So I wish you all a very happy festive season and a very good new year. And we'll see you hopefully in 2024. Thank you.
Bye bye, Lee. Thank you.
Bye. Bye.